Thank you, Judge. I want to go back to the October 31st incident, and I believe we left off with you saying that no one was arrested that day.
Yes, ma'am.
And you all decided to move from the Muskogee area to Florida, right? Can you pick it up right there?
So at that point now we had decided that we weren't moving to Florida anymore. We're now moving to Massachusetts. We went to visit Florida. We went to go see family.
Okay. And what happened on that visit?
On that visit, Maya had to undergo a surgery. So we visited family a little bit and then we focused more towards her surgery.
Okay. And then you went back to Muskogee, or did you move straight to Massachusetts?
No, we went back to Muskogee, ma'am.
Okay. And then what?
We stayed in Muskogee until Christmas and it passed. And then for Massachusetts, I was the first to go to Massachusetts because I had orientation for class. So I drove up from Columbus, Georgia to Woburn, Massachusetts, and I signed the lease.
And that was in December?
No, that's in January.
Right?
Yeah.
January of 2023?
Yes, ma'am.
Okay. And then what happened?
I was up there. It was a little bit of a back and forth because Maya at that time hadn't gotten her leave in, eventually her paid leave for her exiting the Army. Eventually she did. She came to Massachusetts, and upon her coming to Massachusetts, the Army decided to release her not too long after, and we went back. And forgot. So when she came up, I went up. I had to fly back down to pack up all the stuff in the house in an apartment in Massachusetts. I put in storage. Then we all went back up together. Then the Army told her, boom, you have to leave. Like, you can now leave. Then I went back there, put everything in the U-Haul, and drove it back up to Woburn again.
Mr. Dunbar, keep the testimony specifically to the basics. We don't need that much detail. So when you got to Massachusetts, you went first because you had to start class.
Yes, ma'am. You
left your family in Columbus?
Yes, ma'am.
And you signed the lease in January 2023?
Yes, ma'am.
Okay, you went back and got your family when?
I went back and got, the lease ended January 29th. So it was 2 or 3 days before that.
So the end of January?
Yes.
Okay. You started school, and then let's jump straight to March 1st. What happened?
So before March 1st.
I'm sorry. Before we jump to that, before we leave the 1031 incident, was there anything else that happened? No, I'm sorry. I'll disregard that. Go ahead and just tell us what happened on March the 1st, 2023.
What happened the day before leading up to that is Maya and I had gotten to a disagreement or whatnot. Like I kind of like at that point gave her a space. Like I was at a point in which it was like it was just like at this point I felt like we're in a good place and whatnot. Like we had finally left Massachusetts, we had finally left Fort Benning, everything was good. And we got into a disagreement, stayed away from her. I was supposed to go to class, didn't go to class. Went to sleep. She went somewhere else. She woke me up saying that one of my friends called me a narcissist. And I looked at her. I was like, that doesn't make any sense. Like, okay, I know who you're talking about at this point. There's only one person you're talking about. And I called her. And it was Chanel Dennis. She told me to don't say anything for 2 days. She wants to figure something out. And I said, okay. And for the rest of that day and the following day, I literally said yes, no, or bye to Maya. As her and Maya were texting, she revealed that Maya had a plan to leave me financially unstable, take my child and flee the state, and leave me in a $3,500 lease.
I'm going to object. I'm going to object and ask that this answer be stricken, Your Honor. This is all hearsay.
Counsel.
I'm sorry, Your Honor, I didn't hear you.
The objection was hearsay. What's your response?
Your Honor, he is describing what he is aware of, what his knowledge of a conversation was. He's not saying, unless I missed something when someone called just now, but he is talking about what he's aware of.
Okay,
what he has knowledge of. But we can strike it, Your Honor. It's not.
Yeah, it's hearsay. Move on.
So
So, Mr. Dunbar, if you could just stick to what happened. So on March the 1st, we already know that there was a disagreement. Was the police called out?
The police were called.
Okay, and what happened?
I left the gym, went upstairs. Maya spoke with somebody earlier, the maintenance man, Kenny. I was in the gym, he called me, he said, you want to talk? I was like, yeah. Went upstairs, took a shower. I was in the process of taking a shower, put my clothes in the bathroom because I didn't want to talk to her. She put her foot in the door and said, "You need to leave. You need to start getting your stuff. You need to leave now. If you don't leave, I'm gonna get a restraining order on you to break the lease." At the time, I didn't understand what she was saying. I was like, "Maya, I don't want to talk to you. Like, it's crazy what you've done. I know everything." And when I revealed that to her, she blew up. She looked at me, she's like, "You need to leave now." She took my stuff, started putting it in the hallway and whatnot. She grabbed my CPAP machine. I'm diagnosed with sleep apnea. She grabbed my CPAP machine.
I'm trying this girl.
My CPAP machine had water in it. I look at her, I grab it from her. I'm like, "Give me my CPAP machine." She played the damsel in distress, called 911. I'm being choked. I FaceTimed the guy that was in, the maintenance guy. I was like, "Please come here. I don't feel safe." Like, you can see the distance between her and I. When she saw that she was on FaceTime, she left the apartment. Kenny came in. He was like, "Are you okay?" I'm like, "I'm not okay," and whatnot. He walked back outside. I picked up my son Gianni. He stepped outside, went around the corner. Boom, the police were there. The police asked me what had happened. They took the baby from me, and I went on further to explain myself. And she kept saying in the background, "I fear for my life. I fear for my life. I fear for my life." They tried to take pictures of her. She said she didn't want any. They said, "Hey man, we're sorry. You've never been to jail, but you're going to jail." And I was like, "Okay," and I went to jail.
Okay, so let me back you up a little bit. So when the police got there, had you known that they were called?
Yes.
Okay. Had you done anything directly to Miss Jones that day?
No.
Okay. And you've had the opportunity to review the police report, correct?
Yes, ma'am.
And based on what you reviewed in that police report, did they see any injuries to Miss Jones?
Nope.
Objection. Hearsay.
Yeah, he can say if he saw injuries, but I don't think we're going to get this report admitted.
Did you see any injuries?
No, ma'am.
And in your conversation with the police officers, did they say to you that, I'm sorry, in your conversation with the police, did they indicate that, to your knowledge, did the police see any injuries?
No.
No, still not appropriate.
Yeah.
Okay, well, we'll move on. So you didn't see any injuries.
Mhm.
And on that night, you went to jail
Yes.
and they arrested you for, and you know the charges, correct?
Yes.
And the first charge was allegedly an assault on Ms. Jones
Mhm.
and for improper storage of firearms, correct?
Yes, ma'am.
Okay. And on that night, did you actually remove your guns?
No.
Who removed the guns from the house?
The police, ma'am.
And where are those guns now?
They're still in Wilburn PD's custody.
Do you have possession of any guns?
No, ma'am.
And to your knowledge, what was that charge, the improper storage of firearms about?
So upon moving to Massachusetts, we were within our 60-day window. There were 2 assault rifles and 2 pistols. Both 2 assault rifles belonged to me. One pistol belonged to me and 1 pistol belonged to Maya Jones. And whatnot, we were within our 60-day window, and we still had time to get them registered. Yeah. So they were all packed up. They just happened to be there.
Okay. So the charges, as far as you know, were just charges of the way that they were located in the house, not because you had done anything aggressive with them.
Yes, ma'am.
Okay, now let's talk about that case. When that case, you went to jail, correct?
Yes, ma'am.
And you were able to bond out?
Yes, ma'am.
And when you bonded out, what did you do?
When I bonded out, I didn't have much time because I had a court case following or whatnot. Like I got an Uber, went to my parking area, got my car, drove right back to the district court and fell asleep and waited for my my case to start.
Okay, so what did you do in the following weeks after the hearing?
The following weeks after the hearing, I was living from hotel to hotel because I was technically homeless at that particular point. And I was trying to figure out if, with all I had established in Massachusetts, I want to stay there or not.
And you were homeless because what?
I was homeless because there was a no contact order on me in the $3,500 apartment we were in, and I could not go there.
So one of your pretrial conditions was to not return back to the apartment?
I was allowed only under police escort, which they did. I called the police, they escorted me, and I got some things.
So you were only allowed that one time?
Yes, because by the second time, I tried to go back, and I said that I left my medical documentation in a plastic container. By that time, it was already, I had the police call Maya, and Maya stated that she was no longer in the area. So I could not pick up those things.
So you were unable to go back to the apartment that you resided in?
Yes, ma'am.
That was one of the conditions?
Yes.
Do you remember any of the other conditions?
The other conditions was I could not be within 150 feet of her. I couldn't have any contact with her.
Was there any condition that you couldn't have any contact with your son?
No.
Okay. And after being bonded out and being homeless, where did you eventually end up?
I eventually ended up in Alpharetta, Georgia. After I had to break the lease because Maya did not want to be a part of it anymore, I had to pay $3,500 to break it, which also put a dent on me. My family decided, I spoke to my family and friends, they were like, you need to come to Georgia. We have
So
support.
you left Massachusetts and went to Georgia.
Yes, ma'am.
And was the case resolved at that point?
No, ma'am. But because of the first case, they had called her and told her to put a restraining order on me. Like the judge, they literally called her in court and she said she had things to do. They said, okay, but wait till the following week. The second week, they called her again. She said, I have things to do. The judge looked at me, they gave me back my $500 bail, and they said, you have no geographical restriction. Go where you need support.
I'm going to object on the basis of hearsay. We don't know what the court said to her. He hasn't said that he's been a party to that conversation.
Mr. Dunbar, what date, what was your role in this?
At this point, I was defending myself in court, sir.
Okay, so you can say your bail was, your case was closed, your bail was returned to you, and you were told that you could go where you wanted to go. And I think that's all fair because those would be statements explaining conduct,
Yes.
not being offered for the truth of the matter asserted. So we'll move on past it with those adjustments.
Sir,
So I think what he was trying to say is what he heard in court because he was representing himself, Your Honor. I don't think
Still
it's
doesn't- yeah, but he doesn't get to say that. I mean,
right. And I think he was trying to.
sorry, sir.
Go ahead, Mr. Dunbar.
Where should I pick up?
You said you were representing yourself at the time.
Oh, no, like I had a public defender. I had a public defender. Yeah.
Okay. And so was this on the July 25th date? What date was that? Or do you remember?
No, so this was March 4th. It was on the first, March 2nd was the first time I went to court because I had slept in jail. 7 days later, March 9th, and went back. So this was on March 9th when the judge returned my bail to me. I went on.
Okay, so let's move to, did you go to any other hearings after that?
I'm just going to jump in here. The undisputed testimony is that the charges were dismissed in July, and the procedural history of the case at any point along the way is irrelevant to this hearing. So I think we just need to jump past any of the legal stuff unless there's something I'm missing about the significance of it. Now I can't tell if I've frozen because everything's very still.
I'm just trying to make sure. The question I wanted to ask is, did you miss any court dates?
Oh, ma'am.
Were you at every court date?
Yes, ma'am.
And while the case was still pending, what other proceedings did you put in place?
I went through going through the process of the legitimation process for my son now.
And do you remember when you started that process?
Yes, I do, ma'am. I started in April.
April of this year?
Yes, ma'am.
Okay, and then, all right. And on the night of March the 1st, the night of the incident that we're talking about, was there anything that you discovered or saw when you retrieved your belongings?
Yes, I did, ma'am. I saw something gravely disturbing, and it really brought a lot of depression to me. I saw a picture of Maya about 2 hours after I was in jail, taking a selfie with her butt out. Ma'am.
Okay. Could we, Madam Clerk, could you?
I'm going to object if she's going to bring a picture of my client's buttocks into, this is irrelevant.
Your Honor, I think it's very relevant because the picture was taken after the incident that she claimed that my client assaulted her and had manhandled her and mistreated her. And the picture has been altered to conceal her buttocks. But it is a picture that was taken on that night, and you can see the timestamp.
So what?
The relevance is that if the court would allow me to summarize it, just for the objection, the relevance is that the petitioner is alleging that my client performed violent acts on her, and there was no indication of that, or that she was so distraught. And then 2 hours later, she's taking pictures and posting them. We don't know where she posted them, but my client was able to see it on his Apple account where she was taking pictures just 2 hours after he was arrested. That does not show anyone that's distraught or upset.
Your Honor, there's been testimony, there was an arrest, there were criminal charges. I haven't seen this picture. I don't know why this is.
Pause the stream.
Oh, I'm sorry. So did you want me to admit the photo? I'll just
I'm
go through the
sorry. I was
question.
saying that I was admitting the photo based
Oh, okay, I
on
missed that part.
questions Mr. Dunbar, or the answers Mr. Dunbar had given to the questions. And so it's admitted for whatever weight I choose to give it.
Okay.
And you can proceed from there.
Okay. We'll move on, Your Honor. So let's talk about Victor, your Miss Jones's 5-year-old son. How old was he when you all started dating?
There have been no allegations of anything done to or with Victor regarding either your client or Miss Jones. I don't know that we need to go through anything associated with Victor. What would we be discussing in regards to Victor?
Your Honor, we would just be discussing my client's knowledge of the different things he personally observed with Victor's father, because my client was the one who was assisting Miss Jones. And I know it was objected to.
Observed in what context?
In the context of custody, in the context of different proceedings that she filed against the father that my client was aware of because of his interactions and conversations with her. And just
I'm not going to accept the testimony of laypersons about the outcome of court proceedings that are part of public record. Not like that. Not for him to say, oh, this is how divorce or custody or whatever it may be. This is what I was there for. It's
I think it's more so for him to discuss or to talk about what she said to him about what she was doing. But if the court is not going to allow it, then we'll just move on.
we're here to decide what happened between these two.
And I was just presenting it, Your Honor, to be able to establish the pattern that Ms. Jones has when it comes to the proceedings that she files against people, the fathers of her children.
I think there could have been questions on cross about her history of filing protective orders, if any, but even so, I don't, we're here to decide this case based on the evidence and the incidents that are outlined in the petition.
Understood, Your Honor. And Mr. Dunbar, when this case was dismissed in July of this year, at that time, all of the pretrial conditions were lifted against you, correct?
Yes, ma'am.
And at that time, what did you do?
I literally waited 5 days. I thought about contacting Miss Jones immediately on a line of my son. When I thought about it, I was like, let me wait. I waited 5 days. I politely asked her if I could receive pictures of my son, videos of my son. I want to hear my son talk. I offered to pay for 6 co-parenting classes between her and myself, a therapist of her choice, and I would pay for it. And she shut it down. And after she shut it down, I've not responded to her since.
So you only reached out to her once since this case was dismissed?
Yes, ma'am.
And that was in July of this year?
Yes, ma'am.
And after you reached out to her, what happened?
After I reached out to her a week later, I was served with this TPO.
Okay. No further questions at this time, Your Honor.
Cross.
Yes, I just want to ask you a few questions, Mr. Dunbar. You testified that it's your belief that you were charged with improper storage of firearms because the firearms were not properly registered, correct?
The weapons are registered to me. Everything is legal. That's not what I said, no.
Okay, so isn't it true that you were charged with this because the guns were not properly stored so the children would not have access to them?
All of my weapons were way out of children's reach. The only weapon that was within reach of children was Maya Jones' Glock.
Okay, so it's your testimony then that you didn't improperly store those firearms?
By
Charges
Massachusetts.
against him were dismissed, and storage of weapons is not a predicate offense that can be grounds for a protective order under any circumstance. So I'm going to say that this is irrelevant to this proceeding.
Okay. Now I want to talk to you about, isn't it true that actually Ms. Jones disconnected her Apple account prior? You testified you had joint Apple accounts, right?
She was on my family plan.
She was on your family plan, and that's how you had access to anything that she uploaded to the cloud?
No, as a matter of fact, when I disconnected her, if you take a step back, she talked about being in a PlayStation account and messaging people. When I disconnected her from my account is when she went on a rampage and started texting people in the PlayStation account, impersonating me.
Okay, so your testimony is that you disconnected her from your Apple account.
Yes.
Okay, and you did
Family
that
plan,
before or after you
not
were
Apple account,
incarcerated? Huh?
I said family plan, not Apple account, ma'am.
Okay, your Apple family plan?
Yes, ma'am.
Okay, and your testimony is that you did that after you were released from jail?
I did that, yeah, that weekend.
You did that weekend, okay.
Yes.
And
To remove the account was much more difficult. To remove the account that she had attached to the computer. So an Apple family plan is everything. The Find Me, all of that. So when I disconnected her from that, that means all the storage options, everything, she no longer had access to it. She still had an account on my computer.
okay, all right. And you actually didn't have that computer stored on your account. You actually had to have Apple retrieve that for you, correct?
It was, ma'am, it's on my iMac. It's the computer that we're using right now is literally the computer. It was like another user.
Okay. I want to go back and talk a little bit about the 31st of October in
Mhm.
2022. You testified that you never laid hands on Ms. Jones, correct?
I did not say that, ma'am.
You did not say that.
I did not say that.
Okay, so you actually
If
did
you-
lay hands on her.
If you go back and you hear it, I told you I pushed her. Because
Okay,
at this point, she had hit me in the head. She had consistently kept hitting me in the head. As I was putting my son in his crib, my back was turned. I'm literally putting him down, and she was continuing to hit me.
okay. So maybe I'm mistaken. Maybe you testified that on October 15th, you never laid hands on her.
Ma'am, you just said 31st, and now you switched to 15th.
I know. That's because I was perhaps
I'm
confused.
sure that everybody here is ornery because it is 7:45 and we're all used to dinner at 6 o'clock. So I'm going to give everybody some grace. Questions get asked and questions get answered. That's the only way that we do this without
Okay.
putting caught in here and deciding to turn in for the night. And so, yeah, she asked a question. You gave an answer and you clarified it. And now she's changed the question and is asking you about a different date. And when she changes the question and asks a different question, you answer that question too, because she has a right to ask these questions, whether absent a legal objection to them. And that's how we get through the rest of the proceeding. So now she's asking about October 15th. And what is your response about what happened on October 15th?
I'm sorry, sir. I was just.
And I'm sorry, before my client answers, I want to clarify, I don't recall me asking him any questions about the October 15th incident because I didn't ask him about that.
She has a right to a thorough and sifting cross-examination of your client.
Okay.
Ms. Feynman-Sowers, go ahead.
Okay, so I just want to clarify whether or not your testimony was on October 15th, you never laid hands on Ms. Jones.
I don't remember us ever talking about October 15th. I remember 4 dates. I remember March 1st. I remember July 24th. I remember June 27th, 2021. Like, yeah, I don't remember. I don't recall us ever talking about October 17th.
Okay, so isn't it true that on October 15th, you threatened to shoot up the house?
Oh, no.
No?
Oh.
Okay.
I'm sorry, ma'am. All right, it's making sense. So this is in regard to when I found out that that Maya had HPV and my son had HPV, and I went close to go to Georgia. No. I never said that.
Okay.
Whatsoever.
But you do admit on October 31st, you did punch a hole in the bedroom door.
I did because she had loaded an assault rifle. And the moment I heard it crack, my instincts kicked in, and when I opened the door, I was right. She had an assault rifle pointed at the door, and I grabbed it.
I'm sorry to interrupt, Mr. Dunbar. You said the moment you heard what?
I heard a gun racking when.
Okay.
Yeah, so when you load a M4 or M15.
Yeah,
When you
yeah. Okay, I just
release
couldn't.
the latch for the round to go forward.
Okay, so you were standing right outside the door when you heard this?
No, I was in the living room calming, trying to have Victor in a calm space. I had put on Gracie's Corner.
Okay, so that what Gracie's Corner is a children's
Yeah, the children.
television program?
Yes, ma'am.
Okay, so you're there with him with this television program playing. Was the sound on?
Yeah, the song's on.
Okay, and you could hear the gun through a closed door
Ma'am,
with
I've
that
been-
show playing?
Ma'am,
That's your testimony?
I've been in the U.S. Army for 9 years. If anybody's ever heard a release from a latch and a round going forward, it's pretty loud.
Okay, and your testimony is that's the reason why you broke the door?
I put a hole through it, took the weapons out, and the moment I got those weapons out, I took my son as well, and I left. Likewise, when the police came and told me to come back, that's the first thing I identified. Like, A, there are no weapons in the house. The weapons have been removed. Here are the weapons.
Okay. Let's talk a little bit about the police being called. So your testimony was that after this occurred, you grabbed your son and you left the house, correct?
Yes, ma'am.
And isn't it true you actually took her phone with you?
No.
No?
Nope.
Okay. If you had left the house, I don't believe that you would have then it's actually true you don't know who called the police, is that right?
Maya said it was her parents, but after talking to the police, like the time and space was too, they literally told me, hey, bring the child and come right back here. I hadn't even gone up the street.
Okay. So you don't know who called the police. You just know you got a telephone call from the police asking you to return with the child.
Yes, but when I got back to the apartment, they asked me what happened. They further went on, like I explained my part, and they sat us down and they both had us explain.
Okay.
And also,
and isn't it true that you took your arm and you had her in a headlock on October 31st, and you were attempting to choke her?
No, ma'am.
No? No. And isn't it true that that's when she actually bit you, so you would release your arm from around her neck?
No.
So your testimony is that she came at you and bit you?
See, the thing about this is that it wasn't just like it was episodic and whatnot. She blew up, began to calm down and whatnot, and then blew up again.
So again, my question is whether
I
or
did
not
not have her in a headlock when she bit me. No, I didn't put her in a headlock.
Okay. And your testimony is that she just attacked you. She created all these scratches, the mark from the bead ring on your forehead.
The room was.
If you could please allow me to finish, sir. The bite mark, the marks, the claw marks under your arm. Your testimony, I just want to be clear, is that she was the aggressor. She was the one attacking you.
Yes, ma'am.
Okay. Wouldn't you agree that these potentially could be defensive marks as well?
I don't think he's qualified to give testimony on that.
He said he's been in the Army for 9 years. He knows a little bit about
I wasn't a bad instructor.
Mr. Dunbar.
We're moving on.
Okay. Isn't it true that Ms. Jones actually sustained an injury from a pull-up bar back in 2020 before you met her?
Not that I know of, ma'am.
And isn't it true that back in 2020, the injury she sustained from that fall from the pull-up bar was to her head, not to her shoulder?
Well, these are none that I know of, ma'am. That's completely different. I don't know about that. She never told me about
And you weren't present when she supposedly pulled herself on the bar and fell and injured her shoulder, as you testified.
No, I was not.
You weren't present?
No, I'm going off what she told me, ma'am.
Okay. All right.
And I went on to further believe it due to documentation.
just to be, this is my final question. Your testimony is that you've never committed any acts of violence against Ms. Jones.
I've defended myself now.
You have defended yourself. Okay.
Yes.
Your testimony is that you've never been the aggressor. Okay. And I have no further questions.
Redirect.
Briefly, Your Honor, I think that, was it your testimony that you were present with her in 2021 when she was using the pull-up bar?
No, man, 2021 is the incident with Social Jala. Like
I'm sorry, 2022. The dates are the same, they're just different years. June 24th, 2022.
Yes.
You were actually present when she fell off the pull-up bar.
No, ma'am, I was not present.
No.
So you're saying you weren't present on that day. I just wanted to clarify it.
No.
Okay,
I wasn't there when she, like, the pull-up bar, like, no.
okay. And you became aware of that in what way?
When she told me.
Okay. And so just for further clarification about the photograph that was on your iMac, is it your testimony that the iMac, the hard drive on the iMac is where the picture was located?
Yes, ma'am.
Okay, so it's not that you had Apple unlock anything. It's just that the device, the Apple device that stored that information you had, that was your device.
Yes, ma'am.
Okay. And just also for clarification, the opposing counsel asked about an incident that took place in 2020. Did you know Ms. Jones in 2020?
No.
Okay. No further questions, Your Honor.
All right, any other witnesses, counsel?
No, Your Honor.
All right, evidence is closed. Ms. Feynman Sowers, you have the right to open and close, I suppose. What would you like to do?
Well, what I'd like to do is reserve my closing. At this time, I had considered calling my client as a rebuttal witness because there's been new testimony and new allegations here that we weren't aware of until Mr. Dunbar has testified.
Do you need time to speak to your client about how you intend to proceed? Because we can put you two in a breakout room.
I don't think that I do. I just want to ask her about these allegations.
All right, Ms. Jones, you are still under oath. Please unmute for me. Ms. Feynman Sowers, you can begin when you're ready.
Okay. Ms. Jones, you've heard Mr. Dunbar testify as to various facts that occurred on various dates. Specifically, he stated that on July 24th of 2022, you were injured due to falling when you were exercising with a pull-up bar. Did that occur on that date?
No, ma'am. I was never on a pull-up bar that day. I actually have messages between him and I where I told him about my arm and he was like, something, so what? I have scratches or something like that.
Okay, so you didn't injure your arm on July 24th of 2022 due to you exercising?
No, ma'am. That was a Sunday. My mom actually came in town that day and we were spending family time. So I was nowhere near a pull-up bar.
Okay. And I want to ask you, did you sustain an injury from a pull-up bar?
The only injury that I sustained was back in 2020 prior to ever knowing him. And that was to my head. And I've explained to him that that's why I was getting like migraines, like that's what they had determined was that, you know, my migraines were coming from that incident.
Okay. All right. I want to he also, Mr. Dunbar also testified that on October 31st, that you bit his arm. Did you indeed bite his arm?
I did bite his arm while he had me in a headlock. I bit him at the crease of his arm. I did not bite him in the area of the photograph that was shown, but I did bite him in order to get him off of me. But it was when he had me like this and I bit him in the crease of his arm. I didn't bite him on his hand.
So you did not cause the mark, the bite mark as he testified and demonstrated in his Exhibit C?
No, I did not. It was in the crease of his arm, and also from my remembering the photograph that was shown, that photograph, the background is showing in daytime, and when the police came, he's saying he took this picture prior to the police arriving. That the police came, it was already dark. It was already long dark outside.
Okay. And what he also showed pictures of other injuries that he claims you caused, specifically a mark on his forehead, a scratch on his stomach, and marks under his arm. Did you cause those marks on his body?
In self-defense, yes, I did.
You did, okay. All right, I'd like to talk to you a little bit about on October 15th. You, on October 15th, did you make any physical assaults on Mr. Dunbar?
I did not.
You did not, okay. You never punched him when he was putting your son in the crib?
No, I did not punch him. I think I shared with you, I had recordings of the conversation that occurred between us. And that's the same day that he kicked the door and the entire frame came off.
Okay, right, that was on, you showed that was occurred on October 15th, okay. All right. I have no further questions. Your Honor. I'm trying to be brief, cut down on things. I'm through.
All right. Evidence having been closed, Ms. Feynman Sowers has indicated that she will waive opening and reserve closing. Ms. Jackson, I'll hear from you.
Your Honor, briefly, I would ask the court to not issue a protection order in this matter, mainly because my client has not been in contact with the petitioner since March of this year. He only reached out the one time to ask for visitation with his son, which he has not seen since March of this year. All of the incidents that have been discussed today have been, both sides have different recollections of what happened on that day. It's his word against hers. The only thing that seems to be consistent is the whatever the photos are showing. They could be offensive or defensive. And as we have heard, my client has his version of what happened and the petitioner has her version of what happened. However, Your Honor, one thing we cannot dispute is that my client has not been in touch with her, has not violated any of the orders that he was under. The only thing that my client did was file a legitimation petition so that he can establish a relationship with his son and to establish visitation with his son. And in an attempt to try to set that up after having not seen his son for months, Ms. Jones files this TPO. It sounds retaliatory in nature. And the fact that she filed it just days after he asked for visitation, to me, Your Honor, is indicative to that retaliation. She admitted to having already been served with a petition for legitimation. She admitted to answering it, admitted to the fact that she was, that my client was the natural father of her son. And this just seems to be an attempt to try to put a monkey wrench in the legitimation petition that is currently pending in DeKalb County to support her request to have some sort of restriction on visitation. So we believe that this TPO is the makings of retaliatory as a result of my client filing for legitimation. As the court is aware, the charges that were against my client in Massachusetts were subsequently dismissed. And through no fault of his own, he was at every court appearance. And I don't recall if she testified to being at any of the appearances, but I do know that they contacted her and she made the decision not to appear. And if I would argue that if she was that afraid of my client and knew that there were some charges that were against him, which is my understanding, Your Honor, I don't know Massachusetts law, but I did look up that statute and one of them was a felony charge. If she wanted him to be away from her or wanted him to be held accountable for those charges, she could have went up there, showed up for the hearing, and he would have been charged with a felony and he could probably still be on probation, which probably would have had a condition of staying away if that's what her intention was. But Your Honor, I don't believe that that was her intention. I don't believe that she wanted to prosecute it. And that is why they dismissed the charges against my client. And when she realized they were dismissing those charges, she wanted to come back and get a second bite at the apple. The main tenets of this actual petition is based on that March 1st incident. And then she just mentions the other ones to support that. But the main reason, and through testimony from the petitioner, that she filed this TPO was based on the March 1st, 2023 incident that occurred that was subsequently dismissed. So we would ask the court not to put a protection order on my client, preventing him, even though he has not seen her and has no desire to see her, or has no desire to be within 100 yards of her. But we would ask the court not to put that restriction on him.
Ms. Feynman Sowers?
Your Honor, my client has credibly testified as to multiple instances, I'm tired, of domestic violence. Just because she never actually pursued criminal charges against him until March 1st of 2023 doesn't mean that these didn't occur. Mr. Dunbar admits to causing a hole in the door back on October 31st. My client has admitted to causing biting his arm, not in the space that he has indicated, but on the crook of his arm because he was choking her. Mr. Dunbar has also admitted to taking his son and just leaving. And he's not the child's legal father at this point. There is a real concern that maybe he'll try this again. But of course, since there's no legitimation, in effect, she can always seek the police assistance in having her child returned to her. She needs him to stay away from her child, to prevent any further violence or the possibility he'll just pick up his son and take off again. She didn't file this in retaliation. He filed his legitimation petition back in April. She didn't file this TPO action until late July, after the case in Massachusetts was dismissed. It's unfair to classify her as being disinterested and not wanting to pursue that because she couldn't get up to Massachusetts. She testified she didn't have enough notice to get up there for the hearing. She was an essential witness. She wasn't able to get there. So it was dismissed for want of or lack of prosecution, not because these events did not occur. I would argue that actually, I don't know how they operate in Massachusetts, but I don't believe that the police would arrest Mr. Dunbar if there wasn't any sort of cause to do so. He's denied that he has committed any acts of violence against her except in self-defense. I do want the court to take in consideration the size difference of these parties. I also would like the court to take into consideration that even though the one witness, Mr. Lala, came in to on behalf of the respondent, it's undisputed from both the witness and Mr. Dunbar and Ms. Jones that really Mr. Lala doesn't have any knowledge of their relationship other than what he observed back in 2021. He did admit to not being present during the entire time that the parties were together. His testimony could be biased. He's been he was a school friend since 2009. They were in Liberia together. They continued to be friends. Regardless, he still doesn't know much about their relationship. And I asked the court to extend the order of protection for a 12-month period. Thank you.
I don't think we hit the 2.5-hour mark. There are two questions that are at the core of these cases when they need to be decided, and they are pretty much as follows. Have there been acts of family violence committed in which the petitioner was, the respondent was the primary aggressor? And is this order reasonably likely to prevent future acts of violence? And both of those questions need to be answered to make a decision in a case based on the totality of the weight I'm assigning to the extensive amounts of evidence that was presented during this hearing, mostly in the form of testimony. But my finding today is that this order is not reasonably necessary under the circumstances, even if the petitioner has shown that there have been acts of violence in which the respondent is a primary aggressor. Over the last 5 months, there's been a single interaction between the parties. Over the last 9 months, there has been a single act of violence alleged over the course of this hearing. The parties now reside in different states. The only interaction has been through phone from March the 2nd to today, August 29th. And I don't believe this remedy is appropriate at this time and under these circumstances. So the legitimation case will move forward. And I will give all parties the caveat that I give in these situations, which is that despite how it feels in this moment, I have never actually said no to a protective order, but what I have said is not yet. And what that means is that should additional things happen that need to be added to a petition, be those verbal harassment, threats, violence, or anything else, then that petition can be refiled and it will be heard as soon as we are able to hear it, whether that's me or a colleague at the ready. And so understand there will be interactions between the parties moving forward as you try to navigate this legitimation case and potentially co-parent in the future. Involvement in legal processes is not harassment. And so if that's the reason that somebody is filing a petition, well, he took me to court or he tried to do this. Well, that's what the process is for. Your day in court is that day in court. Your day in court is not an additional day in court. However, statements that threaten the well-being, physical safety, family, friends, children of other people, those things are not acceptable. And so what I am optimistic of, there is a legal process that is ongoing right now. And I have two very intelligent, responsible adults who I can tell both care deeply about the child that we are discussing, even if they don't necessarily agree about what is best for that child in this moment, especially as it relates to each other. And so my hope for you both is that this process will play itself out smoothly through the court system and that there will be some sort of appropriate and acceptable outcome to that, whatever that means. So with that, parties and attorneys are excused. They have the thanks of the court. I know this was a long hearing and it is late, but in all sincerity, I am somebody who will crack a joke and engage in the occasional gallows.